Well, good afternoon, everybody. Thank you for coming so promptly to the afternoon session. We are discussing on this panel democracy, surveillance, and intelligence agencies. And I hope you agree we have a really outstanding lineup. I'm just saying some introductions to chair the panel, and then it will be moderated by my colleague, Professor Gerrit Hornung, Professor of Public Law at the University of Passau. And speaking first, we have Peter Swire of Georgia Tech in the US, but I guess many people here will already know that he was a member of President Obama's NSA review panel, which reported shortly before the speech of President Obama last week. Then we have Dr. Constanze Kurz, a computer scientist, but who now does a great deal of work with the Chaos Computer Club. And after that, we actually have a substitute speaker. Ben Emerson, unfortunately, couldn't make it. But we're very privileged to have Louise Arimatsu, who is Associate Fellow at Chatham House and has also taught at the LSE. And she is also working with Ben, has worked with Ben both on the UN drones report and whatever current investigation may result into the PRISM program and so forth by the United Nations. And last but certainly not least, we have Professor Wolfgang Hoffmann-Riem, who until recently was a member of the German Constitutional Court at a time when the court made such groundbreaking new rulings, such as the new fundamental right to digital privacy. So with that, I'll just hand over to Gerrit.
Thanks a lot, Caspar. And good afternoon, everybody, from my side as well. I don't think we need to introduce Caspar to lots of people, but he has this very interesting badge there, which just says independent, and I think that's a very nice affiliation for him to have. Caspar is essentially somebody who has been talking about the NSA and American intelligence surveillance in the last year, and essentially told the public what we now know in the last half year, or got to know in the last half year. We decided to not make a long introduction, and so I would like to hand over the microphone to Peter, who's going to give us a bit of a background and tell us a bit of the work he'd done in the committee.
Hi, everybody. I'm Peter Swire, and my thanks to CPDP and to Caspar, who actually extended the invitation. I was here last year on a panel about Do Not Track, which I was then working on. And one of the high points of the conference was Caspar corralling me outside near the coffee bar to tell me all the things the NSA was supposedly doing. And I thought he was I've known Caspar a long time, I thought he was characteristically insightful. I asked him yesterday what percentage of his accusations from January last year were correct, and he thought a moment and he said 100%. And so this is an issue we've been with for quite a long time, and some of us have been working on it for a long time. I wrote a long article on the Foreign Intelligence Surveillance Act more than a decade ago, talking about how to get more democratic control there. A little my own background, and then I'll go into the review group. I've been working on European data protection law for quite a long time. In 1998, I wrote a book on the US and EU and what to do about the Data Protection Directive. I then went into the White House as the privacy counselor to President Clinton, and was part of the team negotiating the safe harbor in 2000. So these are familiar issues. People have all the views they have about how well or badly that has gone. I see it as having provided a legitimate legal basis for transfers and having helped create a system that's much better than the alternatives would have been. As we did our report, we tried to draw on knowledge about global and European privacy practices. Caspar met with the group and informed our deliberations. We had a delegation from the Libe Committee come over and another delegation from the Commission and the Council come over and met with them. And so trying to have a good understanding of European and global data protection approaches was an important component of the work that we did for the review. In terms of the review group, it came about this August. President Obama and his advisors decided to create this small group. It ended up being 5 people. And we were given a quite broad assignment. We were told that we should try to figure out where to go in order to enhance national security when it comes to intelligence and surveillance. We were told to think about relations with our allies, including the commercial side of that. We were told to examine privacy and civil liberties, how to address the insider threat, which Mr. Snowden had revealed so prominently, and also how to maintain public trust, and that would be public trust at home in the United States and abroad. And so this is a very disparate set of things to try to approach and work on. And we were given staffing, we were given briefings at the NSA and the CIA and the rest at a fully classified level. We were provided the support we needed to try to figure out what has been happening and to try to come up with recommendations of what should happen. The other people in the group were quite a range. One was Michael Morell, who was formerly the #2 person in the CIA. He had spent 30 years in the intelligence service. So if we had questions about how things worked, he had lived through it and had answers. We had Richard Clark, who had been the chief anti-terrorism advisor to President Clinton and President Bush, and he'd also been the cybersecurity lead. So he had been in the war on terrorism for many years. We had Cass Sunstein, one of the most decorated American legal academics who had served in the government, and Jeffrey Stone, a noted civil liberties scholar and a member of the advisory board for the American Civil Liberties Union. And I was in there, I think, especially as a privacy expert and also for economic policy that I'd done. So the hope was to have the multiple perspectives that feed into what the rules should be for how surveillance works in a world where there's so many ways we rely on our communications technologies, partly to fight against enemies and partly to get all the wonders of the internet. So that was a daunting challenge. As you know, we met with the president in August for an hour in the Situation Room. We went and wrote our report. We met with him again when the report was completed. And I can report to you that President Obama is, I think, uniquely capable and suitable for considering these issues. As you know, he taught constitutional law at the University of Chicago. He deeply understands the constitutional fundamental rights issues here. When it comes to the internet, I think you know that he, as he was running for president, et cetera, was seen as a sort of trailblazer, a leader in how to use the internet in innovative ways. And also, of course, he's been commander-in-chief for 5 years in a time of war. So if you think about fundamental rights, think about the commercial and other potential of the internet, and you think about national security for the United States and its allies, he's had the responsibility to bring these things together. And in the meetings, he had personally immersed himself in these issues. And the speech that he gave on Friday was very much the product of his own decisions, working closely with his advisors, being informed by the review group and by many other sources of input. So for this reason, when you read the speech from last Friday, when you read the presidential policy directive from last Friday, I think you should see this as being the result of a deliberate process of self-reflection by the United States government, by President Obama himself. And I think it's a sign of democracy in action. There were public comments to our report. A very wide range of people had input to the process. And then after these months of study, there were announcements last week of a lot of changes. Our report had 46 recommendations. I will not, in the next 2 minutes, mention all 46 of them. But in the president's approach, the report we got is that roughly 70% of them have been accepted in letter or in spirit by the U.S. administration, and others are under further review. So to the extent people have said some nice things about the report, this has very largely been the direction that the United States government has gone in changing these issues. In the next panel, Alex Joel, who's the Privacy and Civil Liberties Officer for the Office of the Director of National Intelligence for Mr. Clapper, he will be on the panel, and Caspar has promised to ask him very tough questions about the meaning of this directive. But for now, I just commend to you, hard as it may be to read bureaucratese, to look at this policy directive issued Friday. Among other things, there's a directive to the intelligence community that privacy and civil liberties shall be integral considerations in the planning of U.S. signals intelligence activities. This is a public, unclassified document, a set of directions to the intelligence community of the United States that these issues need to be taken seriously, that issues are going to be implemented into policy in multiple ways. And if you think maybe this is just pretend language and sort of bad faith attempt to deflect criticism, I encourage you to see this as the constitutional law professor having his opportunity in history to make a mark on how intelligence is done and to integrate fundamental rights thinking into how we do this for the United States of America. So we could do much more, and I'm sure we will in the course of the discussion. But for now, thank you for including us in this discussion. I look forward to further conversations.
Thanks a lot, Peter, for your contribution. I found it very interesting that you said that gaining or regaining public trust was one of the tasks of your group, because we all know that it needs years to build trust and you can lose it in a second, and we're going to see where that goes. Are there any direct questions to Peter? I would maybe allow a direct reaction from the panel or from anyone else. If that's not the case, then we would move on to... Okay, sorry.
You promised to hold yourself back, Caspar.
Well,
I thought I heard you say that directly to me yesterday. Go ahead, please.
Sorry.
Would you take the micro?
I'm sorry. I don't want to knock off the glass. Okay.
I think we have a movable micro.
So we can discuss this later, but immediately I just wanted to inquire if there's anything you wanted to say about the recommendation to give foreigners rights or as-if rights under the Privacy Act, which didn't appear to be in the package recommendations, and the pros and cons and factors behind that.
So the U.S. Privacy Act is a fairly specific law that applies to systems of records held by the U.S. government. The Department of Homeland Security, they do passenger records and immigration, et cetera, has had a policy for several years that for files that contain U.S. and non-U.S. records, for mixed files, the same access and correction rights apply for U.S. persons and to non-U.S. persons. The statute, which is what Congress wrote, only applies it to U.S. persons. So the president has no power to grant judicial rights in any way under the law. It's just not his power to do that. Our recommendation was the same provisions that Homeland Security is doing should be spread to other agencies. That, I've been told, is under further review, and there's been no announcement at this point about what they're going to do or not do on that. So that's, yeah.
Okay. That was an interesting thing to know as well, I think. Okay. So I then hand the microphone to Constanze Kurz, who's going to talk a bit more from the technical point of view on the NSA and other surveillance activities, and is, as I learned, also able to tell us a bit more on a case which is currently at the European Court of Human Rights from the British sphere. There is the activities of the British GCHQ currently challenged, and Constanze is actually one of the plaintiffs of that case, and so she's going to give us some first-hand insights to that case as well, I believe.
First of all, thank you for the opportunity to speak. As you may already know, I have a little bit different opinion than Peter. Of course, that's maybe because I, as most of you, are the victims of those surveillance techniques. And I would talk in the beginning a little bit about what, from a technical perspective, we now know, just to keep it in memory, because we have some months of revelations, and I will just have some short sentences about what it is, what we are talking about. We're talking about monitoring of central servers and backbones, and of course the fiber optic cables lying under the sea on a large scale. And we talk about metadata and the analyzing of that, and of course we talk about offensive hacking attacks and hordes of paid hackers, and actually a surveillance complex on an industrial scale. And when I'm in Germany right now, the discussion is not anymore about the speech of Obama, because on primetime in German television he told us in the face that in the future the surveillance of foreigners, like Europeans and Germans of course too, will go on. That's what he actually told us, and that he just only assured our Chancellor Merkel that as long as he is in position, her mobile phone will not be tapped. And that is, of course, in my opinion, not enough. It's not only a beginning, and it's, of course, a self-reflective speech in terms that he only actually talked about domestic surveillance and not about us, the foreigners. And, the opportunity of history and of change is, of course, in my opinion, not taken. We see from the revelations of Snowden that we're actually dealing with billions of dollars spent on that surveillance techniques. The black budget is part of the revelations we now know. how high the budget is. It's $52 billion. And we talk about numerous intercepting, infiltrating, and analyzing technologies, and undermining the very structure of the security of the internet services. And I guess with some words in a speech to the American nation and in an interview on primetime German television, it's not done. And that is, of course, one of the reasons me and 3 British organizations, the Open Rights Group, Big Brother Watch, and the English Pen, are asking the European Court of Human Rights if we can do better in Europe, because the GCHQ is a little bit different from the NSA, because Great Britain ratified the convention, the Human Rights Convention, and we will try and ask the court if it's possible that we can do better in Europe and not accept that mass surveillance in the future anymore. Actually, the decision of the European Court of Human Rights will maybe be in that year, because we have a fast track. It's a fast track. That means the court prioritized the questions we asked to the British government. And we, of course, hope that in questions of the agencies in the British Empire, we will have different answers and we can cut back on those mass surveillance techniques. Maybe some more facts, at least, about the German discussion, which is different from other public debates, especially different from the US debate, of course, but also a little bit different from other European debates. And that isn't only because Chancellor Merkel's phone was tapped, and it's probably so in the future if another US president will take Obama's place, but it's also because, of course, the German history. I've seen myself, as the wall came down, that such agencies are not lasting forever. And if we see that they cannot be efficiently controlled and there's no really oversight about those agencies, then we should maybe decide to cut the funding of those agencies, because they do no good. And since we know that we just saw a tiny fraction of the documents which Snowden has, and that we will in 2014 and 2015 see even more of those revelations, then at least the German public doesn't buy the terrorism narratives anymore, at least not then, when we don't believe that the EU Parliament, the OPIC organization, Chancellor Merkel, or the leaders of the G20 are top terrorists which have to be hunted. I don't think the terrorism narrative works anymore if we speak about those billions and trillions of data sets which is analyzed and copied, and in a kind of data mafia is treated around the world. And I guess we should stop it here, and I just hope that the European Court of Human Rights will acknowledge that the right to privacy is a human right, and that we are talking about such a mass surveillance that it's a question of our very democracy.
Thanks a lot, Constanze. I'm very curious how the court is going to deal with that issue, actually. I think that's a very interesting case, and maybe we could also connect that to what Wolfgang Hoffmann-Riem is going to tell us later a bit about, namely the legal remedies, which may or may not be there for ordinary citizens as well as regards these intelligence surveillance activities. Again, the question is, are there any spontaneous reactions or questions to Constanze's talk? Yeah, well, please.
Just a specific factual point about whether the president spoke about non-U.S. citizens. So reading from his speech last week, he said, "I have directed that we take the unprecedented step of extending certain protections that we have for the American people to people overseas." And he talked about new use restrictions and limit on duration that are going to be in there. And then he said the bottom line is that people around the world, regardless of their nationality, should know that the United States is not spying on ordinary people who don't threaten our national security, and that we take their privacy concerns into account. And this applies to foreign leaders as well. You may believe him or not believe him, but he was taking an unusual step in an American political speech of outlining, and then in the directive outlining in detail, steps that applied to non-US persons. It was not solely a domestic speech.
Okay. So then we're going to go further and going to go to Louise, who's going to tell us a bit more to the international plane and the international law perspective, because she was part of a team writing a report on that as well. And so, yeah, please, yeah, I hand you the micro.
Well, first of all, I'd like to thank the organisers for this invitation. And although I've taken Ben Emerson's place on this panel, I'm actually not speaking on his behalf. But as Caspar has also mentioned, I will be working with him over the course of this following year in the context of his investigation into a number of issues that have risen as a consequence of the Snowden revelations and which have a direct bearing on his particular mandate. But I want to return to that in a moment. The organisers have also asked me to present some kind of overview of the legal and, I have to admit, I can't preclude the political landscape at the international level. As many of you are aware, in December we saw the General Assembly adopt the resolution on the right to privacy in the digital age, which was sponsored by Brazil and Germany, and we can discuss this in further detail later. In addition to the General Assembly, we've also seen other UN bodies like the Office of the High Commissioner of Human Rights take an interest in these matters because clearly they fall squarely within their remit. Last April, the Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression released a report that, quote, analyses the implications of state surveillance of communications for the exercise of human rights to privacy and freedom of opinion and expression. There's also another excellent report released in 2009 by Martin Schenin, who is Ben Emerson's predecessor, on the protection of the right to privacy in the fight against terrorism. So I commend all those reports. Clearly also we've seen legislators at regional and national levels are increasingly taking an interest in these issues. And why I mention this is that it's really important to see what states are, the positions that states are taking in order to begin to identify how international law may move in on these particular issues. We see also a number of cases pending before both regional and domestic courts. Now, Snowden's revelations have also prompted other bodies, international NGOs, for example, academics and the media, as well as international institutes to take an interest. And the reason why I mention this is that some of you who are present in this hall are probably already aware of the announcement at the WEF on Wednesday of the launch of a global commission on internet governance. Now, this is actually going to be a 2-year inquiry that's chaired by Sweden's Foreign Minister, Carl Bildt, and it's supported by the Secretariat made up of the Centre for International Governance, and I mention this because it also involves Chatham House, where I'm an Associate Fellow. But I want to make this also clear that none of my comments should be interpreted as representing the views of Chatham House, per se. Now, the work of the Commission is going to be wide-ranging, but one of the issues that they will be looking at is the relationship between privacy and surveillance. Now, I want to return quickly to Ben's investigation and give you an update on where we're at with this. The precise framing and the scope of the investigation is still a work in progress. However, broadly stated, the report will be addressing the question of the legitimate balance between a state's obligation to protect human rights and the surveillance of digital information by state officials as a measure to counter terrorist threats. And it's quite narrow in this respect because it has to fall within his remit. Now, the findings will be published in an interim report in June 2014 and presented to the UN General Assembly in September 2014. The groundwork for this particular project began in December last year when we began to identify organizations and experts with which the investigation intends to collaborate. And these will include, for example, the UN Counterterrorism Implementation Task Force, as well as the Office of the High Commission of Human Rights and various other UN-sponsored working groups dealing with internet governance. Clearly, we're also going to be speaking to states too, and clearly the United States and the UK are probably top of the list. Ben very much wanted to attend this conference. Primarily, he wanted to hear what the views of other stakeholders were out there. He wanted to hear them and absorb them and integrate them into the investigation. And so I've been here over the last couple of days trying to gather information, and in order to report back and to feed into this process. But the door is open, and Ben would welcome any kind of input by anyone should you be interested. Before I hand back, I just think I'd like to say a couple of things about the legal framework, because it's important to bear in mind that we actually don't exist, we don't operate in a legal vacuum. And in one way or another, the operations by government agencies, especially because of their extraterritorial nature, fall under a number of different legal regimes. One may be the UN Charter. Certainly some of the interception of the communication activities that Snowden has revealed may constitute espionage. And many of you are probably thinking, yeah, but that's not prohibited under international law, and you're completely right on that point. Nonetheless, it may, depending on what the action is, constitute a violation of other obligations owed by states to other states, including sovereignty, the sovereign equality of states under the UN Charter. It may constitute even a violation of the principle of non-intervention, although that's perhaps a little bit more controversial. But clearly that kind of remedy applies at the state-to-state level. What's really captured the imagination of most people is the human rights framework. And clearly the right to privacy as a human right is not disputed. It's enshrined in domestic constitutions, in various international treaties. And it was expressly reaffirmed in the General Assembly resolution that was adopted in December. For those of you who are interested, it's worth going to the text to see what the General Assembly has called upon states to do. Again, we can discuss this further later on. There are issues as to the jurisdictional scope or the scope of all these different types of international instruments. And clearly, in the case of the US, the ECHR, which would be relevant for the UK, does not apply. But lawyers will disagree on whether or not certain actions of US government agencies fall within the jurisdictional scope of the ICCPR, but that is another debate to be had.
Thanks a lot, Louise. What I find very interesting about this international or United Nations perspective is that this leads or points well beyond what we may call the EU-US controversy. So, and do you think, maybe just a quick question, do you see any sort of uniform views on the relationship between privacy and surveillance on this global scale? Because, I mean, this is not only a US and EU debate if we look at it from a United Nations point of view.
That was certainly one thing that I did want to touch on later on, perhaps in the discussions, that one of the great thing about having a UN perspective is that it brings aboard the international, because clearly these issues apply to all states, applies to all peoples, and the very fact that the internet is global sort of requires us to engage with everyone. And it isn't just a matter of what Europe considers important or how we define those privacy rights within Europe, or even just dependent on just that transatlantic relationship. It is far wider than that. And I think the UN mechanisms provide a great forum within which to remind some of these states that actually, you know what, this is a global issue.
Okay, thank you very much. So we now come to our last speaker of the panel before we open the discussion. And that's going to be Wolfgang Hoffmann-Riem, and he's going to tell us a bit more about the legal remedies and possibilities to actually claim these fundamental rights, if we have any, against intelligence agencies in both Europe and on the world scale.
Well, thank you for the invitation. Indeed, I will talk about questions of legal protection, but mainly related to the norm themselves, in order to show why it's so difficult to have legal remedies effectively used. It has become evident from the reaction on the information about the recent surveillances that legal systems are ill-prepared to effectively ward off such encroachments of freedom. Even though legal protection may be possible in theory, particularly where national laws are violated, or in Europe where the Human Rights Convention has been violated, though there are laws in theory, it is almost unattainable in practice. When individuals use infrastructures for IT technology, they enter into a highly complex regulatory system, one that they are in many aspects incapable of influencing. When personal or business data are accessed by state bodies or private parties, court protection presupposes that such encroachments can be identified and assessed. Users are normally unaware of the way in which communication is processed and where the data are physically located, nor can they be certain as to which authorities collect and analyze information, or the manner in which this is accomplished, or whether companies like Google, Microsoft, or Apple cooperate with the state. Possibilities for legal protection are likely most feasible at the national level. I will address German law as an example, but will also relate to European and international law. Spying infringes on freedoms protected under the German legal system. This is undoubtedly the case where metadata or communication content is accessed using equipment located in German territory, or if it is analyzed there. This clearly involves actions covered by German law, regardless of where the participants of the communication are based. Criminal law, data protection law, and the law concerning personality rights protect against such encroachments. Recourse to the courts is available, at least in theory. In practice, this is possible only if aggrieved parties can assert that they have been personally affected to a legally significant degree. That is, they must, at a minimum, have been aware of the encroachment. Foreign entities, even if endowed with state authority, are also generally subject to German law for acts undertaken in German territory. An exception to this is if these actors are exempt from the applicability of German law, such as under the NATO Status of Forces Agreement. When German state agencies, like the Federal Intelligence Service called the BND, engage in spying, they are bound, of course, by German law. When the BND discloses data to other agencies, such as the NSA, this is subject to strict requirements. It may make such disclosure only with the consent of the German Chancellery, and only where it involves data lawfully collected by it and whose disclosure is necessary in order to safeguard foreign policy or security policy concerns of the German Federal Republic. If the BND were to listen in on communication traffic taking place in Germany or from or to Germany by tapping into a fiber optic cable laid somewhere outside of Germany, or into a server stationed there, or by using a provider located there, this also would constitute an infringement of the freedom of telecommunication, which is guaranteed in Article 10 of the German Basic Law. Such an action can be justified, but only in specific cases, that is, if if it serves to gather information about other countries, only then, and to the extent personal data are involved if some specific restrictions are adhered to. This is, in a very short overview, the current state of German law. I think non-satisfying legal situation. And I will talk why it's not satisfying. In the past, fundamental rights were developed as protection within a national territory, here the German territory. Now the general question arises whether there is an extraterritorial reach of the protection, this means of constitutional rights. The German Federal Constitutional Court has acknowledged such an expansion partly, namely with regard to communication via satellites, if the telecommunications traffic was collected and analyzed with the aid of receiving equipment stationed on German soil, or that the analysis took place on German soil. It expressly left open whether protection goes beyond this. This decision is more than a decade old. We will see whether the court will go further in the future. In my opinion, in view of the reality that modern communication is accomplished using global infrastructure, thinking primarily in terms of categories of spatial localization of the encroachment is no longer adequate. The global reality would otherwise overtake the protection of freedom. The protection of fundamental rights cannot be focused on the contingencies of a path of transport, particularly one determined by third parties without the inclusion of the communicator. But even if this position will be shared, this is controversial, of course, the problem of access to court remedies remains if concrete infringements have not been detected. Therefore, we cannot only rely on the protection of individual subjective rights. The objective protection of fundamental rights must be the point of departure for special protective measures. The starting point must be the importance of protecting not only individual rights, but also the ability of the communication infrastructure as such to be capable of proper functioning, and that includes, in my opinion, that the integrity of IT systems must be assured, and there has to be confidence that effective checks are in place to prevent unauthorized access of such systems. According to my understanding of German law, state bodies are charged with ensuring such functioning as part of their general state obligations. In addition to guaranteeing subjective rights, German fundamental rights norms contain objective protection mandates, and this refers to all norms protecting communication. The objective content of fundamental rights may, under certain conditions, also be reduced to an obligation of the state to protect, not only a right, but an obligation. Essentially, it is not out of the question that obligations and mandates to protect may also make their effects felt in the international sphere and also come into play to counter encroachment by foreign entities. Failure to fulfill national state obligations to protect may, under certain circumstances, though only with substantial hurdles, be challenged in court by resorting to the subjective rights of German citizens. However, breach of this obligation to protect may also bring political sanctions, and in some rare cases may be that the parliament can even initiate a decision of the German Constitutional Court. Of special significance to our topic is a recent innovation of the German Constitutional Court. It invented what it calls the fundamental right to the guarantee of the integrity and reliability of IT systems. This fundamental right was derived from an expansion of the constitutional protection of informational self-determination and the freedom to freely develop one's personality. Even though this protection is guaranteed for the sake of freedom of individual communication behavior, the case dealt with an individual complaint, of course, even though it is specified by the court as a protection of an important infrastructural conditions of modern telecommunications technology, since this function of this system is the prerequisite for the exercise of individual communication freedoms. In order to have a real guarantee of individual freedom, you must also be able to use the communication system which is necessary in order to communicate. In German law, there are several other objective protection mandates which also relate to protecting infrastructures for information and communication technology. These includes a mandate for the protection of encroachments by foreign entities where the target is communication within, from, or to Germany. However, we know that it is difficult to carry out such a mandate. This difficulty does not obviate the guarantee mandate, just the opposite. In my opinion, it magnifies the obligation on state bodies to see to it that protective measures come in place. Just because foreign actors such as the NSA believe that their national laws entitle them to spy on the conduct of citizens of other countries by accessing communication infrastructures for information and communication technology, this doesn't change the fact that German state bodies must work to protect holders of rights fundamentally safeguarded under German law against such infringements. Of course, this is difficult to achieve. Obviously, international agreements will have to be included, and this will be difficult. Since most of the larger companies in the area of information and communication are headquartered in the US, and since they undoubtedly have an interest in having their worldwide activities protected by the US government, some have an incentive to cooperate with US authorities and to block restrictive measures by other countries. The political influence of the US as a global player and the technological, infrastructural, and communicative might of large US companies complement each other. This commercial, political, military complex is threatening to become a hegemonic structure in the world of communication. Nevertheless, it is incumbent upon states, but also the EU, to prevent this from occurring. I now refer to mandates which exist within the framework of the European Union. Protective norms applicable at the EU level also have objective content, at least in part. These include the guarantees under the European Convention on Human Rights. Also noteworthy are articles of the EU treaties, as well as the Charter of Fundamental Rights. I cannot go in detail, but I want to mention that there are several norms available. This obligation to protect also has an impact on the fulfillment of the mandate to establish and develop trans-European telecommunications networks. This refers to Articles 170 of one of the EU treaties. To the extent that protection is achievable only through international agreements, the efforts to reach such understandings form part of the protection mandates under EU law. In view of the significance of the European Union for many areas of life, including for the protection of essential infrastructures, the EU will have to come to see itself as a community for guaranteeing the freedoms not just of companies, but also of individual citizens. I call it a guarantee union. Obligations to protect are also recognized, at least in principle, in international law. You have already mentioned the UN Charter. I also refer to the International Covenant on Civil and Political Rights, especially Articles 17 and 19. These civil rights accords are also vested with objective dimensions. However, there are real difficulties in implementation, as you probably know. I must come to an end. In a globally networked world, substantial protection must take place at the global level, or at least in a globally networked manner, besides protection, of course, on the national level. What is needed is a reform of the protection of freedom at the global level. This may require a paradigm shift, a further surmounting of territorial constrictions in protection of freedom, which has to be coupled with new possibilities for protection, including by courts and new remedies. The designing of IT infrastructures in legal and practical terms affects, as we know, powerful interests, including military clout, the relationship between security and freedom, but also economic competition. In view of the many conflicting interests, it has to be expected that the bodies that are politically responsible for making decisions will only haltingly, if at all, face up the obligation to provide an effective guarantee. This shows that the task of reforming the protection of freedom cannot be, by any means, be entrusted solely to politicians. Academics, as well as non-profit organizations, also need to take up this issue and develop concepts of global governance and the legal structures to frame it. It is also necessary that civil society and the internet communities become massively engaged. One single individual, Edward Snowden, helped at great personal risk to uncover a global threat. All of us are asked to be creative and courageous in designing new modes of governance. Thank you.
Thanks a lot, Wolfgang Hoffmann-Riem. That sounded like the closing remark in the end for the whole debate.
I can repeat it then.
Okay, that's a deal. Very good. I would very much endorse your view that we sort of need to include these objective dimension of fundamental rights, although that we could ask Peter Swire on the US view on that as well, because as far as I know, you don't actually have such a thing as a duty to protect under your constitutional law, or at least not the same
Duty to protect.
A duty to protect fundamental rights.
I think the United States has a constitution that's written and it's been in effect for quite some time. So to say that the fundamental rights are not part of U.S. law is a strange
well, I can
formulation.
say that, actually.
Well, you said there's no fundamental rights under U.S. law.
No.
Oh.
I asked you whether there is a duty to protect for the state, to protect the fundamental rights of the citizens as regards, for example, Wolfgang just explained us, there's a duty to protect under German constitutional law, a duty of the state
the words duty to protect are not inside the United States Constitution. That's not in the U.S. Constitution.
Yeah.
Okay. Are there any specific questions to the debate or the contribution of Wolfgang? Yes, please. Do we have a mobile microphone?
Yeah, you said under the German constitution, the German government would have an obligation to work towards such protections actively. But then you said this might be difficult and take a long time because they would need to get to international agreements and so on. If it turns out that such international agreements are impossible to reach, because you basically would have to have an agreement with every other state on earth, would then the government have an obligation to turn to technical protection measures, such as obliging German telecommunication providers to encrypt all their traffic or things like that?
Could I just ask you to identify yourself if you...
Ralf Bendrath, Senior Policy Advisor for Jan Philipp Albrecht, MEP.
Well, I did not cover all fields which are important. Of course, technical measures are important if they are available to help to reach this goal I was talking about. It's not only international agreements, of course, it's also national law, it's technological, maybe also support for new technological inventions and so on. It's a big field. It's not restricted to international agreements. But since we're talking mainly about law, I wanted to say national law itself is not sufficient, and therefore you need other actors. And I think the Europeans should combine their forces, as if they are possible to do that, at least many countries, I think, would agree, also to put some pressure on non-European countries to enter into agreements. And I would not advise the European Union to sign agreements which have relevance in this subject as well as other relevances, to do this without asking for sufficient protection.
I think Constanze.
Yeah, I would like to add something. I mean, we talked about the legal frameworks a lot, and this is also a debate in the US, of course. We see the suggestion in the US Congress for change, and we see the debates in Europe. But frankly, I know I'm sitting with a lot of members of the jurisprudence here. I don't think the legal framework change will help us right now. In my opinion, the legal framework is plainly wrong and it has to change. That is not a question for me. But I guess what I've learned is that the legal framework of money works better on the short term. And I don't want to wait another decade until the thinking about mass surveillance and the use of technology changed, because we don't have 10 years, because the technology will not be on our bodies, but in our bodies. And that means, what does it mean actually? That means that we have to change, because I don't think the American government, Obama or his predecessors, they will only listen to money. That means we have to ask ourselves, what kind of services, technologically speaking, are we using? And is it acceptable for us to deal with companies which are required by American law to give over the data and to be part of the data acquisition? And that is actually not only a question of the political regulation, which would really help, but it could also be a question of us and the companies in Europe. And that's, you know, I'm asking the European Court of Human Rights, but I guess in the meantime, we should take action and we should think about our own behavior and if it's acceptable for us as customers on a private or a company level to deal with companies in the legal framework, which is now in the US there. That is what I would hope the thinking of the people who are victims of this mass surveillance will help, and more the money framework.
I think Peter wants to react to that, and then I have Louise, and then the gentleman over
It partly reacts to where we're going to find freedom for the global internet. That's been the topic here. And this has been the main place this debate's been played out recently is the role of the United Nations and the internet is through the ITU, the International Telecommunications Union. And those favoring a greater role for the UN in that area have been, the last main resolution was Russia, China, Iraq, and Saudi Arabia. And on the side saying this is not the way to go for global internet freedom were the European Union member states and the United States. So thinking the United Nations somehow is the way to run the internet and that's how we'll get freedom reminds me a little bit of the human rights component of the United Nations, which some number of years ago had Gaddafi's Libya chairing it. So they're you know, in a world where we could imagine institutions that would give us freedom through these international arrangements. But I think empirically, when you see Russia and China leading the charge for an approach, you shouldn't imagine freedom as likely to be the dominant outcome.
Okay, Louise, do you want to react on that?
Yeah, sorry, I just wanted to react in response to a couple of things that the other speakers have said. And I guess it's this, okay? I came to law later in life, but it seems to me that I'm not such a skeptic about what the law can do and what it offers, okay? I do think that at the international level, it takes a huge amount of time, but law does evolve, and what's great about this particular, and it was a third speaker who mentioned this, was that this domain is actually about sort of global democracy. And we're seeing this happen through this particular debate. And I think that should be celebrated and welcomed, okay? While we can be critical, we actually also should recognize that the domain has a huge amount to offer, but also that we do share certain principles, and when I say we, I mean a global constituency out there in terms of what basic fundamental rights there are. It's how we interpret them in particular situations. And with that in mind, I just want to remind people that although we're talking about sort of freedom of privacy, there is also the obligation, a duty in human rights law that's placed upon states, that states need to protect the lives of its citizens too. And this is the process that we're going through. How do we reach that balance? And I think that we kind of forget that element, that there is a duty to protect under human rights law. And how then do we sort of understand how do we craft some of the balancing of, or the give and take that we need to do.
Okay, I have one question over there. Could you please identify yourself?
Sure. My name is Jervis Markham. I work for Mozilla, but I'm speaking for myself. My question is for Peter Swire. We heard just a moment ago about the US Constitution, and that and I know that it contains a statement that people have certain fundamental rights endowed by their creator, and then it goes on to list some of them. And I want to ask a question of quite basic principle, which I think should underlie, if you like, the sort of attitude to the debate in the US. And I would like to hear his opinion, and so far as you can comment, those of the panel and of the Congress and even the President, as to this question. Are these rights outlined in the Constitution given to people because they are people, or because they are Americans?
The fundamental jurisprudence of the U.S. Constitution is that the Constitution puts limits on exercise of power by the state. So the orienting idea is that the state can be too powerful, that King George of England had gotten too powerful, and so there was a right to revolution against this. And in response, in 1787, the U.S. Constitution was created, and the Bill of Rights were added shortly after that, saying the state cannot limit free speech, the government cannot do searches without a search warrant, et cetera. And so the emphasis on that is on limitations on power of the state, not granting duties to the state. That's a difference. Those constitutional protections apply within the borders of the United States to U.S. citizens and non-U.S. citizens. So if you're a European and you're visiting in the U.S., you get all those constitutional protections. But if you're in Brussels, the United States actions as a first instance do not, all the constitutional provisions do not apply outside of the U.S. But it's a limitation on power of the state as the organizing principle, and that applies to both U.S. and non-U.S. persons within the United States.
But in those days, the power of the state was extended mostly within its own borders. Today, the power of the state extends worldwide. Is the power of the state limited outside its borders as well as within it?
So outside of the borders, we had the War of 1812 when the British Navy was going after. I mean, these are early. You're asking for basic constitutional principles.
Yes, I'm very.
And there
happy
was
with your
impoundment
answer.
of American sailors, and there was a war that was fought over it. So outside of the nation, the history is a lot of war, and we try to find ways to avoid that over time. But the U.S. Constitution has very little to say about what happens outside the border as a matter of constitutional law.
Okay.
I have Caspar then, and Wolfgang afterwards.
So it's just following on from what Peter said, and Peter may want to respond to this, but I think it's true that it was only in a 1990 case, very, very recently, unpronounceably Verdigo-Rodriguez, which established that a Fourth Amendment protection against unreasonable search and seizure did not apply to a foreign national outside the US. And it's sort of amazing that that situation was only ruled by the Supreme Court that recently, it seems to me. But also, we must also remember that a central part of the current controversy is what happens to the data of non-Americans when it is sent to US territory for processing. And of course, from a European perspective, we would expect data to have full data protection rights, whosever data that refers to, irrespective of nationality. But the precise problem, and there are other problems obviously, but the precise problem with, say, FISA 702 is it doesn't give rights to foreigners' data whatsoever if they're non-US persons outside the US.
I don't have much to say on that.
Of course, there are differences between different constitutions, and of course there are different traditions. And I know that the American Constitution was designed in order to protect against the state. This is also due to many European countries, including Germany, but times have changed, and we have learned that it is important to have also protection by the states against other power holders, either commercial ones, either other states, and so on. And therefore, there is a tradition in many European countries, especially in Germany, for a long time now, that there is this positive obligation to protect freedom. My second remark, just an information, the German fundamental rights, which are relevant in this area, protect foreigners as well as Germans. They are not restricted to Germans. And my third remark, of course, when we talk about protection against surveillance and protection of the credibility of communication and the integrity of information systems, this cannot only be related to the United States or Great Britain, because Snowden mainly dealt with information from these countries. My hope is that it is possible, and therefore it's not only useful to rely. It's not useful to rely only on law. That also the design of the international global infrastructure will include protections, notwithstanding who will attack. So I think we should think of course, risks which derive from other countries, and of course we should look for solutions which enable people to use the internet freely, even if this disturbs the government, and we should empower the people to use the internet and the other parts of the communications technology, even if they are starting to begin with a kind of a political revolution. I would not deny this, but now we have the special problem of surveillance, especially by NSA and the British agency, but I know that there are other states as well, and of course the German intelligence agency has cooperated. We don't know to what extent. I guess there will be a parliamentary commission looking at this, and I hope we will learn a bit more. And as you probably know, there are plans to even invite Mr. Snowden to participate in the evidence making.
Yeah, I think very much that transparency is a core issue here. Now I have several here, just the gentleman in the front was the first one, and then maybe we can take two questions together then.
Hi, I'm Christophe Clerix, journalist from Belgium. Brussels has a long tradition of being a target of espionage. If we just go back 10 years, in 2003, eavesdropping equipment was discovered in the building of the European Council. More recent, there was a case in which eavesdropping equipment was found in the apartment of a member of Batasuna. The strange thing is that somehow these espionage cases never end up in front of Belgian courts. There's always a lack of evidence material, obviously. But what people tell me behind the screens is that these kind of cases are solved in a diplomatic way. You know, I'm wondering if somebody of the panel could add some more information to this respect. What about diplomacy to solve these kind of disputes, and not laws, but diplomacy? I don't know if it's true, if all these cases that happen in Belgium have been solved with diplomacy. I don't know, but I'm wondering what you think of that. Thank you.
Okay, so could we just take another question? Yeah.
My name is Hiroshi Miyashita, a law professor from Tokyo, Japan. I have a question to Professor Peter Swire. Do you think there is a possibility that the U.S. Supreme Court will declare the unconstitutionality of NSA collection? You already have 2 district court decisions which are divided. For me, U.S. Supreme Court justice is very passive to admit the right to privacy. You know that 2 years ago you have a Jones case where the Supreme Court regarded the privacy as a property right. They use an 18th century methodology to deal with the 21st technology issues. So what do you think about the prediction about the court?
I'm glad to predict a little bit about the court. I think that the U.S. courts in general, when it comes to these searches and seizures, are becoming more aggressive than they were for email and electronic communications. So we had a district judge, lower court judge, say the metadata program, the phone metadata program was unconstitutional, he believed. And I think my prediction is over the next 5 years, we'll see at least 2 or 3 cases in the U.S. Supreme Court where there are stronger protections than they've announced previously. Our report to the president asked for a major study on metadata compared to content, what the legal rules should be about this. That's being undertaken by the president's appointed a board to do that. And I believe that the idea that metadata has no protection, which has been U.S. constitutional doctrine, I believe that's under a great deal of legal pressure and is likely to shift in the next few years.
Okay, thanks a lot. Anyone else to comment on these diplomacy issue? Was it you? Yeah.
Sorry, since the issue of intelligence, or rather espionage, was raised, as I mentioned, you know, there's no international law prohibiting, although clearly domestic law always prohibits. The problem, as we all know, is that all states engage in espionage, you know, and it's not conducive to any state to see any of these revelations brought out in public in a court. So you say to me, you know, maybe we can reach out to the arena of diplomacy to solve some of the problems. Yes, some of the problems, okay, like, for example, tapping of phones by, or the tapping of head of state phones, that kind of issue, yes, I think that will be resolved diplomatically, because there is no other real option for states. Nonetheless, okay, some of these issues go broader than, can we reach some kind of resolution through diplomacy? And because we're talking about different relationships. The first deals with state-to-state relationships. The issue of privacy deals with state-to-individual relationships. So we're in a completely different sort of normative framework there. And it has to resolve in something more than, hey, you know, there is an understanding. Maybe maybe states will be able to reach some kind of agreement over principles, standards, codes of conduct, which they've done in other spheres. So I think that's more likely than some have mentioned, a binding convention, legal document. I don't think that is on the cards at this stage, but I think there can be possibly agreement amongst states for standards and codes of behavior.
Speaking about diplomacy, just a thought experiment. Just imagine for a second that Snowden would not be an American agency contractor fleeing to Moscow, but a Russian fleeing to Washington. Just imagine for a moment, I don't believe in diplomacy anymore. We accept for a decade that the United States kill people with drones, thousands, and no European government said anything. But if such a thing, and it will happen, people, in Chinese and in China and in Russia. If those governments would do, they would earn criticism on human rights level. It's not about diplomacy and it's not about security, it's about power. This is what data actually is. And that is why the European Union has just one chance, using its economic power. That's the only lesson that can be learned by an American government. It's not about diplomacy telling friendly things and have some more promises in German television or in a speech. It's about power, and that is what this data is. And by the way, well, enough said.
I think Caspar wanted to add something on that.
Well, very briefly, most diplomacy is about tangible events in the physical world. If somebody drops a bomb, you can find that out. You can detect physical evidence. But I think part of the problem in general about the so-called accountability agenda in data protection, but also particularly in this area, is you never know when someone else has looked at data. It's an innately secretive activity. So many of the parallels that we would perhaps like to bring across from other areas of international law and diplomacy simply won't work because they're not verifiable.
Okay, I would take a last round of questions because we're running out of time. I have a gentleman here in the front, and then there is the lady, I believe, in the back. And then very briefly, Ralph, because otherwise we're actually running out of time.
Yeah, my name is Tijn Wisman. I'm from the Free University. I was just wondering how much protection you can actually expect from the American Constitution when I heard about, does anybody know the term retroactive immunity? The retroactive immunity that was given to the telco and internet service providers, that was actually lobbied through American Congress. And there's a very interesting book of Glenn Greenwald, it's called With Liberty and Justice for Some, and I think it really underlines how the rule of law in America is close to that. It's not really a question, but more a statement.
More a comment, okay. Then there in the back there was another question, yes. And then we could maybe just have a very brief last round if anyone else, I don't want to push anybody to say something, except Wolfgang, because you have the concluding remark.
Christina Irion, University of Amsterdam. I have a short comment on secrecy and transparency and what is the right standard for mass surveillance programs. And of course I would like to know what the panel thinks about it. So traditionally, surveillance was more targeted, so it was picking out certain individuals that were surveillanced, and mass surveillance today concerns a whole population, possibly the whole internet user community. So the traditional reason for protecting the secrecy of such measures was that they wouldn't want to endanger the whole investigation by revealing who is under investigation. That wouldn't make sense. But by mass surveillance, with mass surveillance, wouldn't it make sense that everybody is aware what kind of surveillance instruments are in place and are used so that everybody is informed? And does this original secrecy paradigm still apply in this context? Thank you.
That's another transparency question. Rav, and then, as I said, I would...
Thanks. Actually, the question came from my colleague here who had to run out to get a phone call, but he's back now, so I hand over to him if you allow.
With whom? Thanks. I'm Leonard Huizing. I work with the Dutch Green MEP. For Mr. Swire, there's a little piece of one sentence in the report that I just can't get my head around, and I was wondering if you could respond to that.
If it's only one sentence, we did better than I thought, but go ahead, please.
Well, there's a couple of others, but this one is, because it doesn't seem to refer to anything that I've seen in the Snowden revelations, it says that governments should not use their offensive cyber capabilities to change the amounts held in financial accounts or otherwise manipulate the financial system. And I was really wondering if you have could comment on why that ended up in the report.
I would love to comment on that because it actually has been made public previously that it's U.S. policy not to interfere with bank accounts and other financial accounts in the financial system, but that has not been widely known. And so saying this here, I think, could be perhaps reassuring, just as it's been previously reported that the United States does not engage in industrial espionage on behalf of U.S. companies and does not provide industrial secrets to help advantage U.S. business or industry. And so we put those in both as recommendations for policy going forward, which already exist, and as recommendations for some of the confidence-building measures internationally and codes of conduct that we think should happen in this area. Thank you for the question.
Okay, then I would give everybody on the panel the opportunity to have a last remark. Should we just do that from left to right? Caspar, do you want to start, or do you want to?
I won't make a last general remark because I'm also on next, but just in answer to that, I did notice that quite an early stage in Snowden, there was an assurance from US authorities, I think a White House spokesman, that the Department of Defense does not engage in economic espionage.
Correct.
The problem is the CIA is not part of the Department of Defense.
The definition of economic espionage is broad, but it's the stealing of industrial secrets to give to U.S. business that's specifically listed in the report, and going broader than that. I think I'll just make my last comment on whether the rule of law is dead in the United States. Should I stop there? I don't believe that's correct. I believe that our federal judges who are appointed for life are extremely highly capable individuals in the main. I believe that we have very active civil liberties organizations in the United States willing to litigate. And I believe that what we've seen in the last number of months is democratic self-examination and a series of changes coming out of that. So I'm much more encouraged rather than discouraged by what we've seen in the last 7 months.
Okay, thank you. Constanze?
I don't think I won't reply to any of the last arguments here. I just want to take a short look into the future. As you probably know, as everybody knows, that the revelations will go on at least 1, maybe 2 or 3 years. I'm quite sure about that. And you can maybe look into your own brain and wait for what to expect. My point, which I want to make, is that I am a human and you are humans, and we don't ask for our human rights. They just belong to us. And that's why we should fight for it against that mass surveillance industrial complex.
So, Louise, do you have any final remarks?
Well, I actually share the feeling of encouragement and welcome these debates. But the only thing that I do want to leave this audience with is that it is hugely regrettable that this entire debate wasn't initiated by states in the first place, and that it took an individual to initiate this debate. And that is truly regrettable.
Well, I have a mandate by Gerrit to ask you, all of us, to be creative and courageous in designing new modes of governance in the field of global communication. Thank you.
Thanks, everybody. Thanks a lot to the panelists, and thanks to the organizers who gave us actually a coffee break. So we didn't eat up the time of the next panel, but just eat up the time of your coffee break. So see you again in 5 minutes to the next PRISM panel.